And for everyone being here. Mr. Landau, I think you mentioned in your opening testimony that a plurality of the cases out there now are from patent assertion entities or patent trolls.
That's correct, and in some months it's the majority.
Where are the rest?
The rest are primarily operating companies, and then to a much lower extent you have university cases, some inventor-started company cases, others that are sometimes called NPEs but are not part of that sort of PAE situation.
What do you say to Mr. Well, first off, I actually believe that there are patent assertion entities and there are patent trolls. And one of the things we need to do is figure out how to distinguish between the two so that we can try and downward trend. I don't think any of you would say, look, an inventor who has a legitimate case should be able to get compensated properly, and at the same time, we shouldn't disrupt that innovation being enjoyed and brought to market. It's a very difficult thing, and I've heard arguments from either side, but I think that it's also important to mention that we're not all patent assertion entities are bad people. Sometimes, to Mr. Babcock's point, they simply there are entities out there that didn't invent, but they own the patent. They just simply are an entity that may have the scale to win if they pursue a patent infringement. I think we need to be realistic about that. So my team will spend a little bit more time really getting down into the details so that I better understand the good actors, the bad actors, and some of the actors that are in the middle. Mr. Babcock, you were the only one who took a few notes when Mr. Landau was doing his opening statement. Are there any things that you want to get off your chest before I go to the academic end of the dais?
Yeah, one thing that really stood out to me, again, just from in practice as a business person, I'm hearing a lot of concern about the PAEs, but I think a lot of the shift of burden shifting that's happened over the past decade or so, where the time, money, and power is now on the side of the infringers, and it takes a lot of money and time for these patent holders to assert. What that's led to is a lot of challenges for those companies that might put them out of business or put them in jeopardy of getting more funding. And so these PAEs are almost a creation of big tech by putting companies out of business, and the patents then end up getting aggregated into more financial entities that assert them professionally at the scale you're talking about. So I don't think that gets brought up a lot in the discourse. It's like there's some belief that there's some like natural order, that there's some PAEs, some NPEs, some operating companies, some professors that invent. I think these are related, and I actually think that some of the evils in the system are created by the burden shifting that has happened.
Okay, and now for the professorial side of the dais here. I'm kind of curious if tell me about if Restore Patent Rights Act were to pass, what elements of the eBay decision would still, if any, be applicable?
The way I understand the act, and I do congratulate you on writing a one-sentence statute, that's very good. I mean, so this would presumably affect only factors 1 and 2 of the eBay test, right? Whether there's irreparable harm can be shown and whether monetary damages would be sufficient to compensate the infringer. The 3rd and 4th elements of the eBay test, which are balancing of the equities between the parties and the public interest, my understanding is that those aren't affected by the act. They're certainly not mentioned in the act, and so I assume that those would continue in effect.
Thank you. I believe the way I understand it is the rebuttable presumption of injunctive relief would bring us back to pre-eBay times. That wasn't the Wild West. During pre-eBay times, what was happening was actually injunctions were granted on the basis of equity. And so if there was a reason, perhaps in the public interest or otherwise, for an injunction not to issue, it wouldn't. And that's that rebuttable part of the presumption of injunction. So I think it doesn't mess with the eBay factors at all. It just returns us to a time prior to eBay when injunctions were generally granted.
And Mr. Landau, I had a question for you on that. I think pre-eBay decision injunction rates were pretty high. What are they today?
So pre-eBay, the injunction rate, it varies depending on exactly which study you look at, but the overall injunction rate was about 95%. For operating companies now after eBay, it's about Again, looking at different numbers, you get slightly different numbers, but about 2% lower. For NPEs, for patent assertion entities, it is significantly lower than that. Typically, I've seen numbers in the 20s.
I see Mr. Babcock agreeing with that.
I would say disagreeing. I'm surprised at the only 2% difference, but
Yeah, it seems odd. We'll dig into it,
Okay.
make sure that we're looking at the same numbers. It seemed odd to me, but I'm not an attorney, so I do ask questions I don't know the answer to. My staff may, but I was just more curious. Look, to the point, I wanted to touch on a point because I think it was something said by an Apple executive about their performing their fiduciary responsibility. I don't disagree with that, to be honest with you. They need to press the system to the maximum extent possible. So I say that to say that I'm not demonizing one end of the spectrum that I generally enjoy a good relationship with because I'm a product of it. I came from big tech. But I still think we have a problem to solve here. And I know that with a one-sentence bill, it's kind of hard to come up with an alternative. But I do believe that I would like for cooler heads to prevail and try to figure out a way that we're getting to the root cause. And this is fundamental fairness for inventors here who want to build things, where it seems to me the status quo puts some of them at a disadvantage. And more importantly, the invention that we never get to enjoy. I don't know what impact that is, but that's what happens when innovation gets stifled and people think that they just can't, as a small inventor, break through. So let's figure out how we continue the dialogue and get to a fair and just outcome.
Thank you, Senator Tillis. Senator Hirono.
Thank you, Mr. Chairman. I thank